I call this meeting to order. Good afternoon and welcome.
124 of the House of Commons of the Standing Committee on Justice and Human Rights. Conformément à l'ordre de
Pursuant to the order of reference of November 18th, 2024, from the House, the committee is meeting in public
to begin its study of the Supplementary Estimates B 2024-2025. We have the Minister of Justice and Attorney General of Canada, Mr. Arif Virani, with us this afternoon, as well as five members of the ministry. Before I introduce you all to the committee, I will say a few words. First, I remind members to please wait until I recognize you by name before speaking. For those participating by video conference, click on the microphone icon to activate your mic, and please mute yourself when you are not speaking. I remind everyone to please address the chair and have all questions and responses go through the chair. Before we start with our committee, I want to also call to your attention that the clerk has distributed la 10e rapport, the 10th report of the Subcommittee on Agenda and Procedure of the Standing Committee on Justice and Human Rights, dans les deux langues, in
both languages.
Further to the subcommittee meeting of Monday, November 25, 2024, où on a discuté les travaux du...
Where we discussed committee work and agreed to make the following recommendations. Firstly, that the meeting of the 20th of November and 16th of December 2024 should be cancelled. Secondly, that for the meetings on the 5th, 9th and 12th of December 2024, the committee will carry out a preliminary study of the Bill C-63
to adopt the subcommittee report. I have two people raising their hands. Mr. Maloney?
My answer to your question is yes. I was just going to move to adopt the report if you hadn't done it.
You, Mr. Brock?
I'm asking that we defer the moving of the 10th report until after we hear from the minister. His time is extremely valuable. I think every member of this committee would understand that and appreciate that. We're 5 minutes in already for his 1 hour. I received no indication that he's available beyond the 60-minute allotment. There is a miscommunication, in my view, with respect to the 10th report. The committee as a whole did not agree with respect to item number 2. There was vigorous debate. I believe we can still reach a compromise. I'm asking that we have that discussion after the first hour and before we hear from the other justice officials to make proper use of our time.
Thank you. Mr. Maloney?
It's a simple matter of voting yes or no to adopt the report of the subcommittee, which we dealt with last week. I think we can do that without any delay of the minister and move on, because we also have the officials here for the second hour.
Mr. Brock?
It's not that simple. We had a vigorous discussion with respect to the merits of another proposed study. There was a compromise that I had put forward for the committee as a whole. I'm not going to get into those details, Mr. Maloney.
Well, I think we're treading very closely.
I know the parameters. Thank you, Mr. Maloney. I'm not getting into those details. I am saying it is not as simple and straightforward as Mr. Maloney and the chair would have this committee believe. Again, I'm respectful of the minister's time. Let's get to the minister, and then we can have a more fulsome discussion about adopting the 10th report. Thank you.
Thank you, Mr. Brock. Mr. Maloney?
I move that we adopt the report right now. The only subject matter of the report is it's outlined very clearly. What else Mr. Brock has in mind has nothing to do with the content of that report. So it's a simple yes or no. We can vote on it. We can move to the minister forthwith.
So the motion's on the floor to
Right, so
adopt
I'd
the
ask you call
report.
the vote.
Okay, yeah. Mr. Clerk? I'm advised by the clerk, the motion's on the floor, so yes. Mr. Clerk?
Madam Chair?
Yes, Mr. Brock?
Moving to adjourn debate. I'm
Meeting?
moving to adjourn debate,
Just,
not
okay.
the meeting.
Can you give me a minute, please? Okay, I'm just going to suspend for a moment just to get clarification from the clerk and the table. Give me a minute, please. Like red, not red. It's not like black or white. I'm sorry, it is black and white. It's not gray. So what I'm trying to say is, the vote has been called, and you can't move on a vote. So I have to do the vote. So clerk, please proceed. Yes.
No, it's motion to adjourn debate.
No. The instructions I'm receiving from the table is that is not allowed
Okay, Madam Chair?
to happen.
Madam Chair, I'm moving to proceed to hear from the minister, which is a dilatory motion.
But the vote has been called, so we can't have another motion. It's black and white, and it's not something that I can decide on. It's already decided. Apparently, it's the same way as in the House. So it's nothing that I need to even make any further points on. So, Mr. Clerk, please proceed with the vote.
Mr. Maloney,
Yes.
Madame Brière,
Oui.
Mr. Mendicino,
Yes.
Mr. Biddle,
Yes.
Ms. Dillon,
Yes.
Mr. Brock,
No.
Ms. Ferrari,
No.
Mr. Van Popta,
No.
Mr. Giovanni,
No.
Monsieur Fortin,
No.
Mr. McGregor.
Yes.
Yeas pour 6, nays contre 5.
Alors, beaucoup. So it is adopted. So I will now introduce I've already introduced that the minister is here, so just give me a moment if you don't mind, Minister, and I'm going to read the persons with you. I want to welcome you, but also Shaleen Curtis Micallef, Deputy Minister and Deputy Attorney General of Canada, Laurie Sargent, Assistant Deputy Minister, Indigenous Rights and Relations Portfolio, Bill Kroll, Chief Financial Officer and Assistant Deputy Minister, Management Sector, Matthew Taylor, Senior General Counsel and Director General, Criminal Law Policy Section, Elizabeth Hendy, Director General, Programs Branch, Policy Sector. So thank you very much. That's for all of you attending. On apprécie beaucoup vos participations.
We very much appreciate you participating with us. And so now I will give the floor to you, Honourable Minister. You have 10 minutes.
Madame la Présidente,
Thank you very much, Madam Chair.
committee members, I'll be presenting today key items from the 2024-25 Supplementary Estimates B for the Department of Justice. This funding will make a real difference for people in this country who interact with our justice system, including victims. These items fit into our government's broader plan to increase affordability, provide social supports, and create a better Canada. Access to justice is a top priority of mine. To this end, I've put considerable time and effort into filling judicial vacancies. I've appointed 178 judges since I became minister. During my first year alone, I appointed 137 judges. The previous annual record was 107. Right now, more than 96% of the judicial positions across the country are filled. A robust legal aid system is another key pillar of access to justice. I believe legal aid provides fair representation. It ensures the smooth functioning of the court process and that cases are heard in a timely manner. This year's Supplementary Estimates B provides $80 million for criminal legal aid for provinces and territories and $71.6 million for immigration and refugee legal aid services. This funding will pave the way to greater access to justice for Indigenous persons, individuals who are Black, and other racialized communities, as well as those with mental health issues, all of whom are overrepresented in the criminal justice system. If these supplementary estimates do not pass in Parliament, this critical support will be jeopardized, and that needs to be understood by all committee members. Justice will not be served. People will suffer, particularly victims of crime. I know that there are colleagues at this table that care about these issues, but I know also that some people may be instructed to oppose these measures. To my Bloc and my NDP colleagues, I think we know how some members will vote on these measures, including the official opposition. I'm looking to you to ensure that the estimates are able to come to a vote and to pass. Permettez-moi de souligner d'autres domaines.
Let me point out some other areas where the supplementary estimates will provide critical support to Canadians. They will support providing of legal advice and information resources for people who have been sexually harassed in the workplace. Sexual harassment is a scourge that disproportionately affects women. Statistics Canada tells us that 1 in 4 women and 1 in 6 men reported having experienced inappropriate sexualized behaviours in their workplaces. We also know that the vast majority of incidents go unreported, meaning that the true numbers are likely higher. Funding of $10.13 million through these estimates would help support people who are going through a traumatic time, especially if they cannot afford a lawyer or do not know their rights.
The legal aid program would support access to free legal information and advice to anyone who believes that they've been sexually harassed in the workplace. This is very important funding. The official opposition asserts that they care about addressing gender-based violence and are often very performative about it. But I expect yet again members will follow their leaders' instructions and vote against supporting victims of gender-based violence. This funding dovetails with a concerted effort from our government to support women and curb sexual assault and gender-based violence. Gender-based violence is an epidemic in this country, and it must stop. This is why we passed, and I worked on this at this very committee, laws requiring training for judges on sexual assault and intimate partner violence. That was Bill C-3, what we call the Rona Ambrose Law, in the 43rd Parliament. We also strengthened the National Sex Offender Registry, Bill S-12, in this Parliament, and reformed publication ban laws to empower victims to tell their own stories. We toughened bail laws for intimate partner violence offenders in Bill C-75 and Bill C-48. We funded women's shelters and crisis hotlines so that victims are supported in their time of need. We will continue to do everything we can to end sexual harassment and gender-based violence in Canada. I'm proud that this funding will contribute to this very important goal. The Online Harms Act will concretely tackle online sexual violence. For the first time, we are mandating that online platforms do their part to keep people in Canada, especially children, safe online. We're ensuring that child sexual exploitation material and non-consensual intimate images, including deep fakes, are subject to a takedown order. Online platforms will no longer get a free pass for hosting vile content. Women and girls across Canada are being intimidated and harassed online. We've seen children pass by suicide because of online abuse. Enough is clearly enough. In our increasingly online world, we do not have time to spare. We need to act. We need to act intentionally. We need to pass Bill C-63. Madame la Présidente, je souhaite maintenant d'aborder.
Now, Madam Chair, I'd like to turn to another matter of importance for Canadians, namely protecting tenants. As we know, one of the biggest pressures on Canadians right now is housing, and this is especially true for renters. With rising rental prices, renovictions, and a lack of available housing options means that tenants are being forced out of their communities. Renters are also faced with unique challenges in ensuring that their homes are properly maintained and that their landlords follow provincial laws. Tenants' rights and legal services organisations can help renters to navigate and overcome these complex issues. When faced with threats to their housing security, renters may be feeling particularly helpless and alone.
2024, our government proposed an investment of $15 million over 5 years to establish what we call a new tenant protection fund. Our government has made substantial advancements in housing. We know that everyone deserves an affordable place to call home. Our Housing Accelerator Fund is making a real difference in communities across Canada. It is very unfortunate that Conservative members of Parliament have been actually barred by their leader from accessing these funds for their communities. That's unfair, and it's certainly not leadership. The Tenant Protection Fund is just one of many elements of these supplementary estimates that will go towards building more housing. Other items include $135 million for the Canada Housing Benefit to provide low and moderate income renters the ability to make ends meet. We're putting $99 million into rapid acquisition of shelter space and deeply affordable housing. We're devoting $27 million to co-op housing development, a great way to increase affordable options for families. We will continue showing up for Canadians and rapidly building the housing that we need. I'd like to speak to one last item, which is new funding of $4.9 million through the estimates for victims and survivors of hate crimes. This funding is part of Canada's Action Plan on Combating Hate. The Action Plan represents Canada's first ever comprehensive cross-government effort to combat hate. Budget 2024 announced $29 million over 6 years, starting this year, to enhance or establish financial assistance and compensation programs for victims of hate-motivated crime. The funding would also help raise awareness in the judiciary about the unique dynamics of hate crime and support the development and delivery of specialized training to Crown prosecutors on this very topic. We've seen an alarming rise in hate crimes in Canada. Horrible incidents of anti-Semitism have skyrocketed. Hate against the queer community is up. People don't feel safe in their own neighborhoods. It is unacceptable, and this is un-Canadian. We need to stamp out hatred in our communities and ensure perpetrators are held to account. Bill C-63 is a key part of our plan to stop hatred in Canada. I was very proud to stand alongside the National Council of Canadian Muslims, the Centre for Israel and Jewish Affairs, the Canadian Race Relations Foundations, and others when I introduced this bill, Bill C-63, in February of this year. I share the disappointment of many Canadians that this bill has been stalled in the House of Commons by partisan gains. C-63 creates tougher penalties for hate crimes, ensures there are mechanisms to hold people accountable for online hate that would not be acceptable in the offline world. I'm proud of this legislation. I hope to see it progress soon. Madam Chair, committee members, the appropriations requested through these supplementary estimates B are part of our government's larger vision of support rather than cuts for Canadians. I'm committed to creating a justice system that is accessible, one that is fair, and one that is efficient. I work every day towards achieving this goal. I hope all members of this committee will work to ensure this important funding flows to Canadians. Thank you very much. Merci beaucoup.
Thank you, Ms. Minister. We will now move to our first round for 6 minutes each. MP Giovanni, please.
Thank you, Madam Chair. Minister, you mentioned tougher bail restrictions in your opening statement, and in the 2024-25 departmental plan, it does mention a key priority being supporting survivors and victims of crime. I'd be curious to know why you think police officers like Sergeant Lisa Harris from Newfoundland and Labrador had to appear before the Status of Women Committee last week asking your government for stricter bail conditions, and why police unions across the country right now are begging you publicly to introduce stricter bail conditions if you believe you've already delivered that.
Minister?
Thank you, Mr. Giovanni, for the question. So what I'd say is that we heard loudly and clearly about the need for bail reform, and we responded to that request that came about 18 months ago. What I'd say about police is that I understand the concerns about police. I feel their concerns. I also know that in my city, close to where you represent, sir, we have 700 less police officers amongst the Toronto Police Service than we did when Bill Blair was the chief of police. I think we need more policing, but we also need more resources dedicated by provinces in things like courtrooms, crowns, JPs, and detention facilities.
There's this sort of condescension in what you're saying, though, when police officers use their voice to express their concerns and you just sort of dismiss it as, well, we dealt with this 18 months ago. They're tweeting at you now asking for stricter bail conditions. And, you know, I've seen you respond to the Ontario government, for example, and suggest that bail law is very difficult to interpret for those without a background in law. There seems to be a streak of condescension, and I'm asking you quite clearly if you're willing to take any responsibility for the problem that police officers are articulating to you, the problem that survivors and victims are articulating to you now.
I take a lot of responsibility for keeping Canadians safe. That is my job. I respect the job that police officers are doing in terms of putting themselves in the line of fire to keep us safe. What I also take cues from are from police officers, including Deputy Chief Alvaro Amida, who has said in York Region that the problem is resourcing in the system, including the availability of court space and crowns. The National Police Federation, an umbrella organization that represents officers around the country, has pointed out the exact point that I've been making, which is that in some jurisdictions, JPs need to have legal training if they're going to make decisions about charter interests. That is not the case in Ontario, and that's an open question as to why.
So I've heard you make this point before, and ordinarily when you speak, you seem to leave out entirely the principle of restraint, the part of the criminal code which many people point to as a source for a lot of the bail issues in our country right now. I'm wondering if you will admit today that the principle of restraint being introduced by your government was a mistake, and that is actually a big part of the problem, that you have not used your powers through the criminal code to enforce as strict bail conditions as many of these stakeholders, these police officers, these victims, these survivors are asking you to do.
So what I'd say, Mr. Giovanni, this predates your time in the Parliament, but when we passed Bill 75, what we were doing is codifying Supreme Court case law, including decisions like Antic and Zora. Nothing changed in terms of the jurisprudence being transferred into black letter law in the statute. In fact, the only thing that did actively change was imposing a reverse onus on people that commit intimate partner violence, making bail more difficult for those individuals. So I appreciate the concern you're voicing. I appreciate the crisis that is happening on our streets. I appreciate the crisis of confidence that Canadians feel in terms of when they see people being let out on bail who have been subject to repeat offenses. The second ground of bail, it's called there's a primary, tertiary, secondary, tertiary ground, is a serious risk of reoffending. That test needs to be applied adequately by the adjudicators, and that involves also having space to house people.
I understand. The issue, though, and you love to bring up that I'm one of the relatively new MPs, but you've been here for 9 years, and when people hear you speak like someone who takes no responsibility for any of the problems in the system. This is the source of frustration. And when you also fail to acknowledge that the principle of restraint in the criminal code is a problem for people, you might disagree with them, but at least acknowledge that their point of view is legitimate, that when police officers ask you to make change, they're coming from an informed position. When victims and survivors ask you to make change, they're coming from an informed position. When provincial governments ask you to make change, they are coming from an informed position. And you continue to take this posture that you know everything, that everybody's wrong, that I just got here. You've been here for 9 years, but somehow that means that you know what you're talking about and I don't. And yet what I'm relaying to you is not my opinion. What I'm relaying to you is what we are hearing from Canadians and organizations across our country. So are you taking the position that everybody just doesn't know as much as you do, and they just simply need to maybe read more of your tweets or your posts to understand better what's going on in the country?
With all due respect, Mr.
So,
Giovanni,
Minister,
my
you
response
have
to your,
time to respond,
yeah,
and
my
that'll be
response to your
time.
earlier,
No,
pardon?
you've got 50 seconds, and that'll
Thank
be
you.
time.
With all due respect, Mr. Giovanni, when you asked me, do I take responsibility? I said that is my responsibility. So I take responsibility. I've just said it, and I've said it twice, Mr. Giovanni.
If I can
continue,
do it.
If I can continue, what I would say to you is that I'm also taking cues from all of the stakeholders in the system. And what is fundamental for Canadians to understand is that you can amend the criminal code, but the implementation of law enforcement is something that resides at the municipal level and at the provincial level. And when I hear Donna Kelway of the Ontario Crown Attorneys Association lamenting the lack of resources so that there are enough crowns to argue about bail, yes, I think that's something that needs to be remedied at the provincial level. When I hear justices of the peace lamenting the fact that the Toronto South Detention Centre is so overcrowded that it resembles third world conditions, there's yet another article in today's news about that very issue. We're jeopardizing the entire criminal justice system. So we need amendments of the criminal code, some of which I've delivered, and I'm willing to entertain more suggestions for further. But what I would say secondly is that we, if I could finish, Mr. Giovanni, what I would say secondarily is that we need
Time's up.
more cops, more crowns, JPs with legal training, detention centres, and we need data. The fact that we don't have the data, and yet Mr. Ford's governance of the criminal justice system is resulting in more than 50% of sexual assault charges being stayed or withdrawn is a problem for everyone in Ontario, including the victims that want to have their day in court. And they're not getting that because there's not enough resources being dedicated to the
So
system.
thank you, MP Giovanni. Thank you, Minister. That is time. What I did notice, though, because we have a substitute clerk, I'm not going to. I don't have the 30 seconds, and the time is up. So I will try when I think it's whatever to just interject a little bit as best as I can. And as nicely as I can. I'm now going to move to MP Biddle for 6 minutes, please.
Thank you very much, Madam Chair. Thank you, Minister, for being here. It's been kind of surprising these last two meetings, looking across the way and seeing a former prosecutor and someone who went to one of the finest law schools in the world pretending they don't know how the legal system works in this country. Especially the criminal. It's not the finest. It's not one of the finest. They're correcting me that Yale Law School isn't one of the finest law schools in the country. I guess that'll be on division. I think it's pretty good. Humbly from the University of Windsor Law School, but in any event, Mr. Chair, or Madam Chair, I was wondering, Minister, if you could comment if there have been any court decisions with respect to the resources that are available with respect to bail.
Absolutely been. So in a case called Mushemi, and I'm quoting the justice here, he said, even if pretrial detention conditions were rendered more humane, the decision to deprive someone of their liberty before they have had a trial and the Crown has proven its case should be made sparingly. Given the utterly dehumanizing conditions at the Toronto South Detention Centre, it must be made even rarer until those conditions improve. So that's a case called R versus Mushemi. Just in today's newspaper, they're actually referring to the fact that the Toronto South Detention Centre is horrific, where conditions are described as, people are described as being filthy, underfed, and caged, prompting Madam Justice Himmel of the Superior Court to again decry the situation and actually reduce the sentence. Normally there's a sentencing discount. I think most people in this committee understand that. She actually upped the discount because of the conditions being so deplorable, pointing to the need for better conditions, including more facilities to house people, but also to house them more safely. That is jeopardizing both the conditions of detention, but also Canadians' confidence in the administration of justice, particularly in the province of Ontario.
And I guess it goes back to the Conservatives misleading in terms of how the justice system works. Why can't you, as the Federal Minister of Justice, deal with these conditions in these jails that justices are talking about, as the members of the Conservative Party are suggesting you do?
Because it would violate the division of powers under what's called the old BNA Act of 1867. The administration of justice is the purview of the provinces. I set this piece of legislation like the criminal code. I appoint judges, but I do not build courthouses. I do not hire court workers. I do not hire crowns. I do not hire police. I do not track data, and I do not build provincial detention facilities.
It's interesting, Minister, that the Conservatives are laughing when you're talking about the division of powers and the Constitution. There clearly is no regard for that, and there's still heckling, Madam Chair. There's still heckling when we talk about issues like the Charter, when we talk about issues like the Constitution. The Conservatives are completely unserious when it comes to issues of the Constitution. I was wondering if you could discuss, I know you have the online harms bill before the House. Hopefully the House will get back to its regular business. But I've had the opportunity to meet with a lot of parents on this subject. And I know everyone around this table is concerned about what's online and what's out there. And we even heard Conservatives, they did have a lengthy filibuster during their own bill, but one of the themes they talked about significantly was the ability to take down provisions from the internet. And even though the private members' bill they were filibustering didn't have that provision, I'm wondering if you can talk about the provisions of the Online Harms Act and how it will make Canadians safer, because I know a lot of parents are concerned about that.
Mr. Biddle, thank you for that question. So there will be a duty to protect children and a duty to take down material that would be imposed in legislation. First 2 points. Secondly, the duty to take down material would apply to child sex abuse material and what is also known as revenge porn, the non-consensual sharing of intimate images. And when I've spoken to mothers, and I've spoken to a lot around this country, when they talk to me, specifically Amanda Todd's mother, Carol, she said to me that the victimization of her child continues 10 years after death. Why? Because the images continue to circulate of Amanda Todd online. When I've spoken to law enforcement, as Mr. Giovanni was urging me to do, what law enforcement has told me is that you can amend the criminal code as many times as you want. It's very difficult to prosecute in this area. It's especially difficult when the perpetrator is in a foreign jurisdiction, including halfway across the world. The only thing that they've told me that will help these families and these victims is getting the images down and doing it fast. That is what this bill would purport to do on a 24-hour timeline, get the images down. That is why the Canadian Centre for Child Protection is behind it, as are parents right around this country. And that is at least one thing I hope we can work collaboratively in a nonpartisan manner to get across the finish line.
If I can ask a question, Madam Chair, about bolstering legal aid, can you talk about the impact it will be on people if we were unable to administer the additional $151 million because of the Conservative filibuster in the House?
Well, it has to do with stuff you guys deal with on a daily basis, which is about access to justice. And what we're facing with is a problem with lack of courtrooms, but also court backlog. What you do when you implement legal aid is you ensure people are represented. A represented litigant moves through the system much quicker to whatever disposition, up or down, yes or no, civil damages or not, conviction or not, but they move more quickly through the system. So when I put on the table $700 million of legal aid for immigration, refugee legal aid, and criminal legal aid over a span of 5 years, what I'm doing is that I'm enhancing access to justice and the efficiency of our justice system. Again, that is something that we should all be behind, because we need a more efficient justice system to ensure that people get their day in court and they get the kind of results that they deserve.
Thank you, Minister. Thank you, Madam Chair.
Merci beaucoup. Alors maintenant, on passe à...
Thank you very much. Now over to Mr. Fortin for 6 minutes. Thank you, Minister. Thank you for being with us today. I'm going to put a question to you. The Bloc Québécois put forward a bill, C-373, which proposes to eliminate certain exceptions in the criminal code under 319(1)(b) and 2B. So can we expect that your government will take up this bill and support it before the end of the current legislature? I am completely aware of what you've put forward as a party on C-373 when it comes to exemptions to religious defences in the criminal code. I think this refers to Section 319. Now, if you want to move ahead with this bill, first of all, we have to get beyond the impasse in the House, to be quite frank. And if you want to move faster, there's already a bill that aims at the same sections in the criminal code, namely 319, Section 319, which refers to online harms, and it's Bill C-63. Sorry, but we don't have much time. So C-633 does not deal with religious exemptions, which is dealt with in C-373, but simply to abolish religious exemptions. Both of these, are you in favour of that, yes or no? And if so, can we expect that this will move ahead quickly if, of course, the House gets beyond this impasse? Very briefly, we're talking about the same sections in the criminal code, so that could be an amendment, which is in order. And then secondly, on this subject, I'm quite at ease to discuss this situation, have that studied by your committee with witnesses, because my main objective is to eliminate the level of hatred that we see currently in Canada. But do you not agree with me that we have the same objective? We also want to eliminate hatred. but to allow religious discourse to take place under religious pretexts is certainly not compliant with the Canadian Charter nor Quebecers and Canadians' values. So do you agree with me that that is problematic? Now, this dates back to about 20 or 25 years ago, and it would be good to study how often this has been used where the accused person actually succeeded by using this type of defence, because I don't think there's many cases where this came up. I agree with you. I don't think it's been used often, but the problem, Minister, is that... Are you listening to me? Yes. It's true it has not been used very often, but the Crown prosecutors have, when launching proceedings, have this possibility in front of this and ask this question. I've got X files in front of me and various proceedings. I'm not able to launch all of these actions, and so I have to give my Crown prosecutors the cases that are likely to succeed. And under Section 3191B, etc., are always damaging, because this sends out a signal whereby if it's done under religious protection, then that would be a valid defence. So simply yes or no. Is it problematic for you as well, or do you think it's not a problem to allow for religious discourse to take place on the pretext of this religious defence? My answer is yes. And do we need to study how we need to change or amend legislation to fight against hatred? Well, we've got our suggestion in C63 to increase penalties. If you want to remove certain excuses or defences, I'm quite open to that approach as well. So it's good if you're able to listen to me, but it'd be good if you're actually in agreement with me. But I understand I'm not going to get that agreement today, but I do invite you to think seriously about this, because here in the committee, we've held many hearings on Islamophobia and anti-Semitism over the last few weeks. No doubt you've heard about our debates here. And this is a question that I believe is increasingly relevant, increasingly urgent. After having listened to all of this testimony, there was the government representative of anti-Semitism, Madam Lyne, who came before us. And she agreed. She believed that this was an interesting point that should be further explored. So that's why I'm insisting on this point and hammering it home. It would be very important when fighting against hate speech. And now I'll quickly change for my last minute, roughly, Minister. There was an article that came out this morning in La Presse where we were deploring the problem of the nomination of Quebec judges to the federal court. No doubt you've read that, or no doubt you've been briefed on this at least. And over the next few days, I imagine, there will be 2 new Quebec judges that will be named and appointed to the federal court. Can we expect that you will actually designate Quebec judges, because this is an obligation in the federal courts to have 5 at the Federal Court of Appeal and 11 at the federal court. There is a deficit in terms of Quebec judges. That's been raised in Quebec today. So can you correct this deficit in terms of nominations of Quebec judges? Because there are these open vacancies. Can we see these filled in the next few days? My response is that I have done my work very quickly. I've already acted very quickly, quicker than any other Canadian minister. And the current figures for the whole of Quebec, the posts filled are 96.8%. So there's around 3%, 3.5% roughly in terms of open positions. Can I fill these vacancies for the Federal Court and Federal Court of Appeal with Quebec judges, as is laid out in the statutes? I will, of course, follow the legislation and my obligations laid out in the legislation. Thank you very much, Chair. Thank you, Minister.
6-minute round for MP McGregor, please.
Thank you, Madam Chair. Thank you, Minister, for joining our committee once again. I was looking through both your departmental plan and org chart. Now, in the org chart, you do have reference to a war crimes program, and in the departmental plans, there are commitments towards international cooperation on criminal justice. However, when it comes to the supplementary estimates, I don't see any reference to funding for both these, and I'm just curious, with everything that's going on around the world, with Russian aggression in Ukraine, with what's happening in the Middle East, in Africa, can you explain why no additional resources are being devoted to these very important programs if we're serious about standing up for Canadian values internationally?
Thank you, Mr. McGregor, for the question. And what I'd say to you is that we've definitely worked on our international cooperation. We've definitely enhanced our collaboration specifically in the context of the Ukraine conflict. There are Department of Justice employees that have been seconded to the International Criminal Court, for example, RCMP assisting with investigations, et cetera. With respect to the actual numbers, I might defer to Bill Kroll or my deputy in terms of the numbers dedicated to the War Crimes Unit.
Maybe I'll get to him during the second round. I have a direct question for you. With respect to what's happening in the West Bank, are the illegal Israeli settlements there, does that constitute a war crime?
I think the Government of Canada's position is
That's
the
a
same.
yes or no question, Minister. Is it a war crime or is it not?
The status of the settlement, the West Bank is an occupied territory. The status of the settlements is that they are illegal at law. That has been Canada's position.
War crime, I mean, they're displacing the indigenous population, the Palestinians who used to live there. Is that a war crime?
So what I'm telling you, Mr. McGregor, is Canada's position. The investigation and determination of a war crime is for an international tribunal. It's not for me to speculate.
Okay, but we are signatories to the Rome Statute. You have seen recently that the International Criminal Court has issued an arrest warrant for both the Prime Minister of Israel and his former defense minister. When asked about that directly, both the Prime Minister and your colleague, the Minister of Foreign Affairs, stated, and I'll quote, "Canada will abide by the ruling." What does that mean? What does abide by mean, Minister? You're the Minister of Justice. In plain English, what does that mean? What does that mean when Canada will abide by that ruling?
So, Mr. McGregor, I'll simply restate what is Canada's position. We are a rule of law country. We are signatories to the Rome Statute. We respect our institutions and their independence, including international
Abide by
institutions.
mean, like if the Prime Minister of Israel and his former defense minister were to set foot on Canadian soil, what would Canada do?
So, Mr. McGregor, I'm not going to speculate on future hypothetical situations.
Well, I'm not asking you to speculate.
what I will
Both
say
your
to you-
colleague and the Prime Minister were quite clear in saying that we would abide by. I'm asking for a clear answer.
And I'm echoing exactly what Minister Joly and what the Prime Minister said, which is that we are a rule of law country. We're signatories to the Rome Statute. We believe in international humanitarian law and the jurisdiction and independence of the ICC.
Minister, the ICC issued an arrest warrant for both the Prime Minister and the former defense minister for crimes against humanity and crimes committed since the Israel-Hamas war began more than a year ago. Both the Prime Minister and the Minister of Foreign Affairs have said they would abide by that ruling. You acknowledge that we are a signatory to the Rome Statute. You have been wavering in clearly committing an answer towards whether these illegal Israeli settlements constitute war crimes, and you're being equally evasive in stating, as the Minister of Justice, on what Canada would do should both of these individuals set foot on Canadian soil. I think Canadians would like to have a clear answer from their Minister of Justice on this.
So I dispute that characterization, Mr. McGregor. What I'm indicating to you is that I don't answer hypotheticals. I've indicated to you the status of the West Bank and the settlements as illegal at international law. And what I've said to you is that what we've frequently said, which is that we abide by international law, we abide by international institutions, we respect their jurisdiction and their independence, and the signatories of the Rome Statute will continue to do so.
I understand that it is a contravention of international law, Minister, but again, we're talking about the West Bank, which is future land for a Palestinian state. It is acknowledged that these are Palestinian territories. These people are being forcibly removed, and after they are being prevented from returning because of the building of settlements. So again, very clearly, does that action constitute a war crime, and would Canada hold those people responsible for that kind of conduct?
Mr. McGregor, I'm trying to assist you as best I can. The determination ultimately about what constitutes a war crime is for an international tribunal to determine. That is not before me, and I'm not going to speculate about it. What I can say to you is that Canada's policy has been the annexed territory of the West Bank is an occupied territory, and the settlements themselves constitute illegal settlements. And we've articulated that many times over the past many years.
Okay, well, I'm going to push back on this. I mean, in your departmental plan, under the heading of International Cooperation on Criminal Justice, it says, and I quote, Justice Canada will continue to support Canada's criminal justice priorities internationally, ensuring that Canadian values and approaches are considered in the development of international norms and standards. And it lists on crime prevention, criminal justice, genocide, crimes against humanity, and war crimes. If you're not even able to give a simple answer, I mean, what are Canada's values on those things? You can't even give me a clear answer on something that is very clearly happening in the West Bank at this moment. What are our values if you as the minister are unable to provide a clear answer at this committee?
5 seconds.
I, again, dispute your characterization, Mr. McGregor, and what I would say to you is that our values are that we should uphold our institutions, domestic and foreign, and that we should respect the rule of law and international humanitarian law. And that is what we've always sought to do.
Thank you very much. We will now do the second and final round for 5 minutes. Mr. Van Popta, please.
Good. Thank you, Mr. Minister, for being here with us today. According to the departmental plan, the percentage of Canadians who have confidence that Canadian criminal justice system is fair to all people stands at 50%, only at 50%. I find this shocking. So my question is, how is that conducive to a strong, free, and democratic society that half of us don't have confidence in our criminal justice system?
Well, to be frank, Mr. Van Popta, what I'd say is that confidence in the criminal justice system gets undermined by two things. One is underinvestment in the system, particularly in terms of building the infrastructure, having the personnel to staff the system. But secondly, it's about people taking shots at and encouraging disrespect for our judiciary, including members of the Supreme Court of Canada. And I've unfortunately seen that on repeated occasions from none other than the leader of the Conservative Party, and I don't think that helps with the narrative about building up confidence in our institutions.
People express concerns. We hear it all the time. Are you suggesting that those concerns aren't real? And I'm thinking that maybe you don't, that you don't believe them. You had said shortly after you were appointed into your current position, I think that empirically it's unlikely Canada is becoming less safe, but I think there's a sense coming out of the pandemic that people's safety is more in jeopardy. So, you know, it's in their heads, right? Empirical evidence suggests otherwise, but I'm looking at a recent study from the Fraser Institute about our worsening public safety record compared to the United States. And since 2014, violent crime is up in Canada and has now surpassed that of the United States by 14%. And property crime also exceeding the USA by 27%. So can you acknowledge that the subjective feelings that Canadians have about a worsening public safety situation is not just in their heads, but is backed up by empirical evidence?
There's absolutely empirical evidence of worsening crime statistics. I acknowledge that full frontal. And what I would say to you is that when we're concerned about people's perceptions of crime, it's about their confidence in our institutions. And I think when we have decisions that are being rendered and we're having underinvestment, it erodes that confidence. So what I would point to is some of the interventions I made earlier about the need to ensure we have enough police officers, enough Crown attorneys, enough courtrooms, enough court space, and enough detention facilities to house individuals. It's not lost upon me that actually 81% of the people in Ontario are actually on remand right now, so they're awaiting trial. That's a pretty startling statistic for most people to digest, but it's also not lost upon me that JPs and judges are commenting on the deplorable conditions of said detention facilities as a disincentive for them to deny bail and keep people housed. That's really, really important to underscore.
Yes, we've heard that from you recently, that trying to shift the focus to provinces, and they should be doing their part of under shared jurisdiction under criminal law. But yet, Bill C-75 is a federal law which focuses on the principle of the least restraint possible. So that's your law. So is there? And we hear so many people expressing concern, police authorities and premiers saying more needs to be done when it comes to bail reform. Now, is the concern with stricter bail conditions one of perhaps it being challenged as being unconstitutional? And in this environment today, where repeat violent crime is really becoming a scourge on our society, like, doesn't that pass the Oakes test under Section 1? As being an immediate problem that needs to be addressed, and that stricter bail conditions could pass a constitutional test such as that?
Well, we imposed stricter bail conditions through Bill C-48, which is important, and that dealt with serious violent repeat offenders. Whether that's being applied and implemented in an appropriate manner by justices of the peace who do not require any legal training in the province of Ontario is a question that I think every Canadian should be asking, particularly every Ontarian. What I would say to you, I'm glad you bring up the Constitution, Mr. Van Popta. I don't think it helps to support Canadians' confidence in our institutions or in the judiciary or in our legal system when the response to what needs to be investments is simply to say we should contemplate invoking the notwithstanding clause to override charter rights. Because that's exactly what's come out of the mouth of your leader, unfortunately.
I just want
and that to me is
that.
problematic for somebody who professes
I'm talking about
to be
the
established
Section 1
freedoms
test.
as opposed to overriding freedoms.
I'm sorry, sir. You're trying to put words in my mouth. I'm not talking about a notwithstanding clause. I'm talking about laws passing through the Section 1, the Oakes test, as
Time's
being
up.
constitutional.
Thank you.
I'm not trying to put words in your mouth. It's unfortunately your leader who put those words in his own mouth.
Oh, thank you to both of you. Alors, Madame Brière, vous avez 5 minutes.
Madame Brière, you have 5 minutes. Thank you, Madam Chair. Thank you, Minister, for being with us this afternoon. Friday, 6th of December, we will be sadly remembering 35 years since the anti-feminist tragedy that took place at the École Polytechnique in Montreal. And still today, there are many violent crimes that very much have an impact, especially on women. And all parties seem to wish to support victims. In your departmental plan, one of your priorities is the safety of Canadian populations in communities and online. First of all, I'd like to know, what are you doing to protect women against sexual harassment in the workplace? There are several measures, and we've already completed various stages. We adopted C3 in the 43rd Parliament, which means that new judges have to take training on sexual harassment. And during that Parliament, with S12, we re-established the National Sex Offenders Registry, which especially impacts predators against women. And twice we made changes as regards bail. For example, for those who are victims of intimate partner violence, IPV C75, that was in the previous Parliament, and now a C48 in the current legislative period. So we have taken several measures. Something that is a cause for concern for me is that in the provinces, in particular in Ontario, we see a situation where, because of the unreasonable delays issue, there are victims of sexual harassment and gender-based harassment who are not getting their day in court before a judge to plead their circumstances, and so we're not seeing accountability vis-a-vis the accused, and that's because there are not sufficient provincial investments in this. There are several articles that have just come out on that issue at a provincial level, in particular in Ontario. Thank you very much. You have also asked for 4.9 billion for funds to support victims and survivors of hate crimes. How will you use that funding? And there's C63 that will be coming before this committee soon. But what are other measures that you've taken to fight against the rise in hate crimes? You've mentioned several. Thank you for that question. On that particular bill, for the very first time, we've introduced the word deep fake for the first time, because we're not just dealing with a situation where there's a sharing of non-consensual intimate images, so-called revenge porn, as we say in English, but there's also depictions of women that are completely artificial, but the impact is the same for the women in question. Either it's truly her or it's a representation of this woman, but either way, it's the same impact. It's revenge porn. It's to punish the woman, to isolate her, to frighten her. so that she's afraid of actually engaging in social media discussions. That's why this is such an important bill. It's not just for adult women, but also for young girls with Amanda Todd and Pearsons, and also with young boys several times now. We've seen that they're targeted by predatory attacks, and they don't have the ability nor the tools to actually counter this type of attack. And sometimes there are these extremely tragic events. It can lead to a suicide of a teenager. That's why this bill is so necessary, and it's a strong one to fight against predators and also to safeguard our young people and our adult women also. Thank you once again. Another issue that's a real cause for concern for me is access to justice. Justice Brown from the Federal Court said in February 2024 that there were not enough judges. In your introductory comments, you've said that we're now at 96+% of vacancies that have been filled, that you have nominated many judges. What is the actual state of play currently? So Justice Brown was talking about 40. Now we're in just around 30 open vacancies. I have appointed 137 in my first few months in post. The record before that was 109, so I exceeded that by about 30 extra judges. I'm going to continue with the nominations at quite a steady pace, and I'm going to continue to do so because we have to fill all of these vacancies, because that's absolutely necessary to give access to justice to everyone. It's interesting for me to observe these articles that talk about the situation for victims of sexual harassment in Ontario. They don't talk about a higher level, the Superior Courts. Rather, they're talking about the Ontario Court of Justice at a provincial level and how we have to accelerate and expedite things at that provincial level also. Thank you. And now 2.5 minutes for Mr. Fortin. Thank you, Madam Chair. Minister, in 2.5 minutes, so very quickly, please. This morning in the media, I read that there's a terrorist entity that's going to be added to the register of terrorist entities, namely a group, I'm just looking for the name, the Hansala. And it's been added to the register of terrorist organizations. And I imagine it's because that would get the job done. It would be useful, I imagine, to put these organizations on a register to combat terrorism. I've got a question. I put forward a bill last week for the creation of a register of criminal organizations. Do you believe that would be a good idea to add criminal organizations to this type of register, as we already do with this register, our registry for terrorist entities? Well, that's an interesting suggestion. Now, when it comes to a list of terrorist organizations, we do a great deal of due diligence to examine the situation. This involves our international partners from outside Canada, and it takes some time to reflect on this first. If we were to establish the same procedure domestically for organised crime, I'm not sure whether we could do that. We could certainly look into this. It's a good idea. I agree with you that organised crime is rising now here in Canada, so we have to be better equipped to fight against that scourge. Do not believe that this type of registry would be useful. If it's already working well for terrorism, perhaps it could work well also for organised crime. Well, perhaps we need to look at this with our counterparts within the G7 to see whether that type of registry already exists elsewhere. Well, here we're talking about what's happening domestically in Canada, not abroad. I'll leave that with you, and we'll go to another issue. You talk a great deal about your judge nominations record, but when I look at this respectfully, and of course I've got a great deal of respect for you, as you know, Minister Jody Wilson Raybould, you've really beat her in terms of your records for the federal court. She was at 128, and you're at 283, and she was at around 400, you're at 700, and for Quebec, you're at 200, and the Superior Court, she was at 158, and you're at 185. So sometimes it's practically the double. So can you explain, please, why there is this big gap between what the former Minister of Justice, Jody Raybould-Wilson, did compared to what you've done? Time is ticking, so very quickly, Minister, I know it's very difficult. I'd just like to underline something, answers the Minister. She comes from BC, Jody Raybould-Wilson, and for the Superior Court of British Columbia for about 34 hours. The position, in fact, was filled very quickly between the 26th and the 28th of November, and I will continue to act in an extremely rapid fashion.
Mr. McGregor.
Thank you, Madam Chair. Minister, in the estimates, you announced that one of the votes is $3 million for funding for the Tenant Protection Fund. And then under the Canadian Human Rights Commission, the total voted $1,158,000. That is all going to the Federal Housing Advocate. Now, you know that my colleague, MP Zarrillo, has been bringing up the issue where some large corporate landlords, Dream Unlimited in this case, has admitted using AI software, which the American government alleges can be used by landlords to collude and coordinate rent increases. So this is I think most Canadians would agree, a very unfair business practice. It might even be illegal. Do you feel like with all of the pressures that tenants are facing these days against the organized might of corporate landlords, do you feel that $3 million in these supplementary estimates to protect tenants and this $1.158 million for the Federal Housing Advocate, do you believe, like with the scope of the problem that Canada's tenants are facing from coast to coast to coast, that these are adequate amounts of money to effectively address the problem that they are facing, the challenges that they are facing?
Well, I'll speak to you as a guy who used to work at a few legal clinics, and what I'd say is that it's important when you establish a tenant protection fund that it's funded sufficiently to give people the legal assistance that they need. I would just underscore, Mr. McGregor, that it's $3 million this year. It's a $15 million fund. Could more be dedicated? Absolutely more could be dedicated. In cities like mine, there is a intense commercialization of rental properties, and it's having detrimental impacts, including rent evictions. What I would also say is that by increasing the supply of rental units, what you're giving is people more options so that they're not effectively held hostage by predatory corporate landlords.
I just want to be clear from the outset, I do understand how separate your role has to be from any criminal prosecutions, but can I ask you in a very broad manner, what interest is the Department of Justice taking in these issues that tenants are bringing up, especially if big corporate landlords are starting to collude using this AI technology?
So our interest is in distributing the funds that will support the tenant advocates in terms of financing those advocates. Obviously, when it comes to a prosecution or potential prosecution, that is handled by people who are independent from me as they need to be. So the PPSC at the national level, and then obviously at the provincial level by provincial crowns in Ontario or BC, as the case may be.
Thank you very much to Minister. Thank you very much to the MPs around the table. This concludes your appearance with us this afternoon. I'm going to suspend for 2 minutes. 3 minutes, thank you, to allow your departure, and then we will continue on up until our time with the witnesses that are here. Thank you. there's no need for statements. That has been done. So we're continuing for the benefit of Mr. Fortin, because I know he's going to ask later. Alors, it's les tours subséquentes.
So the minutes are a bit different for the next rounds of questions, and the turns are a bit different as well, but I will follow the information on this sheet up here. So now, Ms. Ferrari, you have 5 minutes. Thank you very much.
Thank you so much to the officials here. So what we have here is we have officials from the Minister of Justice's office. These are the folks that are working alongside this office. And, we just heard testimony from the minister, and to call it appalling would be kind, to be honest with you. As somebody who sat in the status of women for the last 3 years, who has, listened to the stats on women being murdered in broad daylight, including here in Ottawa, just down the road in a park in front of her 2 children, where her throat was slit and innocent people had to hold her while she died in their arms in front of her children. And the minister said, we've reformed bail, and these people that are committing these crimes are out on bail. It was a very insulting testimony to victims of violence. And so I think it's very pertinent that I move the following motion. It was put on notice on November 26th, and the following motion reads that given the members of Parliament committed to 16 days of action to combat gender-based violence, and that 1 woman or girl is killed every single day in Canada, and that since 2015, sexual assaults have increased 74%, sexual violations against children have increased 118%, kidnapping has increased 10%, harassing communications have increased 86%, and human trafficking has increased 83%. The committee report to the House that Liberal criminal justice policies have failed to protect women, and that the committee undertake a study of no less than 2 meetings during the 16 days of action to combat gender-based violence to hear from survivors of domestic violence, experts, and advocates. And so I'm asking for some retribution, because what the minister said here today in committee was that they've done a tremendous job. He himself has done a tremendous job in combating gender-based violence. And so I'm moving this motion to hopefully get the support of every member in this committee to say, okay, let's study this. Let's actually let victims have their voices heard. We had Sergeant Lisa Harris from Newfoundland Constabulary. She testified in Status of Women last week, and she said, the death of Courtney Lake, and it's really important we say victims' names, highlights the tragic consequences that can happen when those accused of intimate partner violence are allowed to remain free on bail with little repercussions for breaching court orders. Her story is one of many that demonstrates the urgent need for stricter bail conditions for those accused of intimate partner violence. Madam Speaker, if we are serious in this Justice Committee, I would urge every member to vote in favour of this study, to bring forward the victims who definitely need to have their voices heard, but also to implement the policies that can be made today to stop this insane attack on women and gender-based violence, and especially in our northern regions where we also have an epidemic. Just a couple weeks ago, we had a young woman who was 16 years old who was brutally attacked in broad daylight, and again, her attacker was out on bail. Police in northeastern Ontario respond to over 100 intimate partner violence calls every single week. We have to agree this is the Justice Committee. If people are serious here, we have to do something. And so I will leave it at that, to this motion, that I plead with the members of this committee to take this very seriously, because 187 women were killed violently in Canada. That is 1 woman every 2 days. And according to Peel Regional Police, a woman is strangled every single day in this country, and we can do better.
Mr. Maloney?
Thank you, Madam Chair, and I want to thank Ms. Ferrari for bringing forward this motion. Look, gender-based violence, well, actually, the minister's on record time and time again describing it as an epidemic. So to suggest that anybody doesn't take it seriously would be a mischaracterization in the extreme. And it is a topic that merits discussion at this committee, other committees, and Parliament as a whole. But I think, given the, I would like to see this motion reviewed very carefully, perhaps expanded. I know that we do have witnesses here today, and we do have our schedule and our timetable full until the end of this session, till Christmas. So I would suggest that I move to adjourn debate to allow us the opportunity to consider this further down the road.
Really putting your money where your mouth is, James? Kate'll love that answer.
Yeah, well,
She's watching you right now, just so you know.
and she knows how seriously we take this.
Yeah, real
So,
serious.
so we have a motion, and I need to call a vote on it.
Mr. Maloney?
On the motion to adjourn.
Okay, gotcha.
We have a motion to adjourn debate.
And I just wanted to clarify
Yes.
what we're voting on. That's all.
Yes. And so I need to have the clerk deal with that before proceeding any further.
Mr. Maloney?
Yes.
Madame Brière? Mr. Mancino?
Yes.
Mr. Biddle?
Yes.
Ms. Dillon? Mr. Brock?
Conservatives will always stand on the side of victims, so I am voting no.
Ms. Ferreri?
Absolutely not.
Mr. Van Popta?
No.
Mr. Giovanni?
No.
Monsieur Fortin?
No.
Mr. McGregor?
Yes.
Yes pour 6, nays contre 5, 5.
So, Madame Ferrari, I'm gonna, you've got, I'm gonna give you 2 more minutes if you like for the witnesses.
I'll take it for sure. Okay, thank you to the chair here. So one of the things that has come up repeatedly in terms of what is not protecting victims on the street who are being hurt and murdered by repeat violent offenders who are out on bail is Bill C-75. Police Chief Stuart Betts testified in Status of Whitman that said, "We know that the release from custody is a ladder principle and that the least onerous form of custody is to hold that person accountable for their behavior while they're awaiting a trial, and that is what we are letting people out on. Often, that is perhaps underserving victims in our community because the least onerous, depending on the nature of that offense, is insufficient to protect our community once they've been released." A Liberal member then tried to question him and saying, "It's the application of the law, not the law itself, correct?" And Chief Stuart Betts said, "I'm sorry, it is the law itself as well as how it's currently being applied, but it is also the law." So my question to the officials is, what are you doing to change and implement Bill C-75 so that violent repeat offenders are not getting out on bail?
Thank you for the question. Maybe I can say a couple of things. The first I'd point you to is the recent meeting of FPT ministers responsible for justice and public safety. So this is all ministers, provincial and federal, met in October and agreed that there continue to be challenges in the bail system, and agreed that through them, their officials at all levels of government should continue
Sorry,
to
Madam Chair,
collaborate.
and my frustration and anger is certainly not directed at you. I know your officials. But the Minister of Justice is the minister responsible for justice in the country, correct?
The federal minister of justice is responsible for
10 seconds for Mr.
Sure.
Taylor
So
to
we
respond.
don't need a
No, Ms.
meeting.
Ferrari, he's allowed to respond.
He did. We
No,
don't need a
he d-
meeting. Yes, he did. He
Well-
just responded. We don't need a meeting about what's not
time's up.
working.
I'm
we need,
sorry,
we
time's
need
up.
action from the Justice Minister. Thank you.
Time's up. Thank you. 5 minutes to MP Mendocino.
Thank you, Madam Chair. Thank you to the officials for appearing this afternoon. And I would like to focus my questions on Bill C-63. The context for this legislation is the Government of Canada's concern about the alarming rise of online harm and crime. And I would begin by pointing out that the prevalence of online harm has continued to increase over the last number of years. In 2022, a Canadian Internet Use Survey revealed that 71% of Canadians aged between 15 to 24 had been exposed over the previous 12 months to online content inciting hatred or violence. And in that same year of 2022, the Uniform Crime Reporting Survey reported 219 cyber-related hate crimes, which was up from 92 reported incidents in 2018. I would highlight a few other important statistics. Between 2014 and 2022, police reported 15,630 incidents of online sexual offenses against children and 45,816 instances of child pornography. In 2022, police in Canada received 2,524 reports of non-consensual distribution of intimate images online, and a 2020 study by the UK-based Institute for Strategic Dialogue found that Canadians were sharing white supremacist, misogynistic, and other radical content in more than 6,600 online channels, and that Canadians were proportionally more active in such channels than other users abroad. Now, Madam Chair, I take the time to go through these statistics to underline the importance of this legislation. And among other things, the bill identifies and provides definitions for 7 types of harmful content, many of which are directly responsive to the alarming trends around online harm, violence, and crime that I have just elucidated. Those 7 types of harmful content include content that foments hatred, content that incites violence, extremism, and terrorism, intimate content communicated without consent, content that induces a child to harm themselves, content that sexually victimizes a child or re-victimizes a survivor, and content that is used to bully a child. So in my remaining time, I would like the officials to expand on how they see these provisions being, once implemented, able to be deployed by law enforcement for the purposes of reversing the trends that I have identified, and that are one of the main reasons why it is so important that we study this bill, we pass this bill into law. And I'll open the floor to whomever wants to take the question.
Thank you for the question. Mr. Mendicino, I think, helpfully kind of identified the context and the main themes of the bill. As you will know, the bill is divided into a number of different parts. Mr. Mendicino talked about the part 1 of the bill, which focuses on creating a new regime, a new infrastructure to be able to address harmful content online and to be able to take steps to remove that harmful content online. He touched upon issues around child sexual exploitation and abuse material that part of the bill will be able to address. But I would also point out that the bill also proposes amendments to what we refer to as the Mandatory Reporting Act to strengthen that tool to address the ability for law enforcement to investigate, respond to this behavior. And then
Can I stop you right there? Just sorry to interject, but I'd like to, in my remaining time, hear more about the mandatory reporting regime, because this would be a novelty in this particular area of online harm. So can you just expand on that?
Yes, thank you for the opportunity.
Very briefly, few seconds
Very
left.
briefly, the Mandatory Reporting Act is an existing piece of legislation that allows for the reporting of child sexual exploitation and abuse material to centralized police agencies, the RCMP. That in turn allows the RCMP to share that information with law enforcement partners with a view to investigating and addressing that conduct in Canada.
Merci. Thank you. OK. Monsieur Fortin,
Mr. Fortin, you have 2.5 minutes. Unfair. Good afternoon, ladies and gentlemen. Thank you for being with us. So with just 2 minutes, I raised questions with the Minister of Justice. You weren't here, so I won't repeat all of that. One of the question of appointments of judges. The Chief Justice of the Federal Court, Mr. Yves de Montigny, said that there was not adequate funding when he was talking about all of this in his speech in 2023. And then there was Justice Brown, who handed down a decision in February last, who said that the number of unfilled positions was unacceptable at the Federal Court. And the Honourable Chief Justice Wagner, a couple of years ago, I believe, said on a few occasions that the time to get appointments was really unreasonable, and this was undermining the public's confidence in the justice system. So I would like to hear from you on that. Is something being done in the budget? Are there additional sums to create justice positions and stop there being stays in proceedings because of unreasonable delays as under the Jordan ruling? And is there going to be more funding for more courtrooms and more personnel to unblock this situation, which is very much undermining the image of the justice system? And over time, it could create a significant crisis because, as I said, it does undermine the public's confidence in our judicial system.
Merci. Merci pour la...
Thank you for that question. This is not a question for the Department of Justice. Rather, this is a question for CAS, the Court Administration Service, because they are the ones who deal with these matters. Thank you. I do understand, but you're here to talk about the budget with us. Okay, my time has not run out yet. So are there any sums allocated in the budget for new posts for judges or to speed up the appointment of judges? Very quickly then. Well, not in the budget from our department. Not in the Department of Justice's budget. Thank you very much. Now, Mr. McGregor.
Minutes, please.
Thank you. Excuse me. Thank you, Madam Chair. Thank you to the officials for continuing to stay with our committee. I wanted to focus my question on the part of the supplementary estimates that are providing those additional funds for legal aid for refugees and so on. And I want to place this in the context of the ascendancy of a second Trump presidency. He will, of course, be inaugurated on January the 20th. And we do know that there are members of his inner circle who have been talking about, quote unquote, mass deportations and so on. I'm just curious. I'm not asking you to comment on American politics, but I'm really asking you to sort of look ahead and maybe inform this committee on how the Department of Justice is preparing for what that could mean at the Canadian border. Are these supplementary estimates and are your plans taking into account what the situation might be post-January 20th? Do you expect the demand for these types of services to increase post-January 20th? Are any kind of departmental plans being put into works to maybe be prepared for that contingency?
Hi, thank you very much for the question. So the funding that's in the Department of Justice's estimates and supplementary estimates for immigration and refugee legal aid is money that we provide to the provinces and territories, mainly the provinces that deliver immigration and refugee legal aid services. We obviously are in contact with those provinces, with those legal aid service providers to maintain and understand the forecast from April 1st until now and potentially what they would be to the end of the fiscal year. And we take that information and we use that to work with our other colleagues, but we're not at this time forecasting an increase over and above the $71.6 million that we need to get to the end of the fiscal year, and it's part of the supplementary estimates.
Thank you. And very quickly, I know the minister in his opening statement talked about the judicial vacancies that were filled. Do you have a rough estimate with the current demographics that we have on like what the vacancy rate will be like going into the future? Do we expect a lot more vacancies heading our way because of the current demographics of sitting judges? like how close they are to retirement age, et cetera?
Thank you for the question. I'm afraid we don't have that answer.
Thank you. That's time. So I know this is a little bit different than we've done, so I'm going to bear with me. We now go back to, we will, Mr. Brock for 5 minutes, then Mr. Maloney for 5 minutes, and then I'm going to reassess my time up to the time because I need about 10 minutes at least at the end because I've got 7 questions to pose about the supplements. So just bear with me, and I will look at the time. But now, Mr. Brock, you have 5 minutes.
Thank you, Chair. And all my questions can be answered by any official, no one in particular. I want to push back a little bit and correct an error that I believe the government is pushing through the House and delivering to the public. I know the minister spoke about Antic and Zora in response to a question regarding the failings of Bill 75, but I want to have everyone reflect on what those 2 key seminal decisions pronounced. It indicated as follows, that for most alleged crimes, release on bail at the earliest reasonable opportunity with minimal conditions is the default position. These decisions make clear that the principles operate alongside the grounds for detention and do not replace them. That is very specific language. Do the officials agree with the ratio of those 2 key leading decisions, yes or no?
Yeah, thank you for the question. I agree with everything you've just articulated, Mr. Brock.
So then why is there an imbalance, a specific wording imbalance that has created the crisis that this country has seen with respect to bail decisions? 493.1 was amended by the Trudeau government in 2019, and it reads, in making a decision under this part, a peace officer, justice, or judge shall, mandatory language, shall give primary consideration to the release of the accused at the earliest reasonable opportunity and on the least onerous conditions that are appropriate in the circumstances. Language right out of the Supreme Court, including conditions that are reasonably practical for the accused to comply with. And then at the very end, a tagline, while taking into account the grounds referred to in section 515 sub 10, the primary, the secondary, and the tertiary. That is not a balance. That is telegraphing to justices of the peace and judges that default is the primary consideration, regardless of the predicate offense, regardless of the offender's criminal record, regardless of a track record of breaches of the administration of justice, and regardless of overall his background. Is the current government open to strengthening the language under 493.1, where we're dealing with individuals who are creating the majority of menace on our streets, continually violating bail conditions? Is the government open to the possibility of amending that language in 493 to ensure that judges are placing equal emphasis on all 3 grounds enumerated under 515 sub 10?
Thank you for the question. I think you emphasized a couple really important points that bear repeating. That 493.1 operates alongside the primary, secondary, and tertiary grounds of bail, Mr. Brock, such that where detention is warranted, detention should be imposed. Minister Virani did allude to his openness to looking at ways to further strengthen the bail system, and just to
Mr. Taylor, how long do victims, how long do premiers, how long do police chiefs, how long do presidents of unions have to wait while this government sits and considers? We are in a crisis. Victims are so disappointed in this criminal justice system. I hear from them daily. My colleague Michelle Ferreri hears from them daily. Mr. Van Popta, Mr. Jamil Javani. We are hearing from victims. We are hearing from stakeholders. This government is not ensuring a balance. How long will it take for this government to provide the necessary tools to judges and justices of the peace so that they can hold those repeat violent offenders accountable?
It's a good question, and unfortunately, it's one that's best addressed to the minister. I can say that we are working very actively with our provincial partners. We hear those concerns as well as public servants responsible for advising the government on the criminal justice system. We work with our provincial partners. We work with policing partners. We're alive to those concerns, but as to whether law reform would be advanced either by the government or Parliament, that's not for me to comment. Thank you.
Thank you very much. Mr. Maloney, for 5 minutes, please.
Thanks, Chair. And thank you to our witnesses for being here. I appreciate your testimony and that of the minister. And the questions from my colleagues, I will add to that list too. And I want to pick up on something that Mr. Brock was just trying to get at and something Mr. Fortin referred to earlier. It's important, in my view, to understand the distinction between the responsibility of the federal government and the provincial government, and to some extent the municipal government when it comes to law enforcement. So on Mr. Fortin's point about judicial appointments, he talked about stays of proceedings and more money for courtrooms, and that's what I want to talk about. If you go into a superior court in Ontario, the judge is appointed by the federal government, the judge is paid for by the federal government, but everything else is the responsibility of the province. Is that not the case? I don't know who wants to answer that, but you're all nodding your heads in the affirmative.
Yes, that's correct.
Okay. And that includes the courtroom, the number of courtrooms, the courthouse, the light bulbs, the staff, the Crown attorneys, across the board. Is that right?
Yes.
And similarly, and I'll use Ontario as an example again, when it comes to detention facilities, those fall under the jurisdiction of the province as well, do they not?
Yes, sorry, provincial detention facilities, remand facilities would fall to the responsibilities of the provinces.
Right. So if somebody has been denied bail in the province of Ontario, they're going to end up in one of those provincial remand facilities, correct? So if there aren't enough Crown attorneys and there aren't enough provincial detention facilities or enough room in those provincial detention facilities, there's nothing the federal government can do about it, is there?
I think there, insofar as conditions in provincial detention facilities, that is entirely the responsibility of the provinces.
It's not the federal government's responsibility to build courtrooms or to build provincial detention centers. Correct. Okay. So that's why that article that the minister referred to in the media today was so important in highlighting this, because unfortunately you're seeing a lot of politicians try to, put blame on their opponent as opposed to trying to find appropriate legal solutions. And that's really the point I'm trying to make. And that goes for the bail laws too, because although not all the members are in the room today, I've heard it from conservative legal authorities who I respect that we don't need new laws, they just need to be better enforced. And that goes to what the minister was saying earlier about the justices of the peace and provincially court judges who are the ones who are responsible for hearing bail applications if they even get to them, because there's enough grounds to put them before them and they're not waiving the hearing. Is that a fair statement?
Correct. And the federal government's responsibility would be around legislative development, but the implementation and the administration of those laws is a responsibility of the provinces and territories.
Okay, thank you. So now I'm going to move on to, I think it was something Mr. McGregor was talking about, that's legal aid, because that's another area of jurisdiction which gets a little bit muddied in terms of people's perception about areas of jurisdiction. I practiced law in Ontario for 20 years before I went into politics, and legal aid was always something that fell under the jurisdiction of the province. Is that accurate? With the exception of immigration. I'm going to get to that in a second.
Criminal legal aid is with the provinces.
Criminal legal aid, that's right. Okay. So, and in the last 10 years, certainly since I've been a member of Parliament in 2015, there's been some significant changes to the role of the federal government in terms of how it's getting involved in the criminal legal aid or other components of legal aid. Maybe you could sort of take us through that on a high level.
Sure, thank you for the question. In this supplementary estimates, there's additional $80 million for criminal legal aid, which would be coupled with $440 million over 5 years from budget 2024. So that would be additional money that would go to the provinces and territories' legal aid plans for this year. There's also additional funding, as I explained to Mr. McGregor, for immigration and refugee legal aid of $71.6 million, which would go to those provinces that provide legal aid in immigration and refugee services. That is also money that is required for this fiscal year. In addition, there is workplace sexual harassment funding that is for legal advice for claimants of workplace sexual harassment. That is also runs through the legal aid program. An additional $5 million in the supplementary estimates this year, an additional $10 million over for this year also for public legal education, for legal advice for those individuals, and then also for, and
No, that's fine.
okay, and I'll stop there.
You're good?
Thank you very much.
Thank you. So members, bear with me. We are now at 5:11. I am going to shorten a little bit to give each one. This is a subsequent round. This is not the norm, but this is what happens when we have this kind of a session. So I am going to give 2.5 minutes on this side, 2.5 minutes on this side, and then Monsieur Fortin, you've got 1.5 minutes, and Mr. McGregor, 1.5 minutes, and that'll bring me to time.
I ask the question.
That's why I'm trying to explain the process, because it's not one that we've dealt with in a long time in terms of how we time this. So, Mr. Van Popta, you have 2.5 minutes, please. I believe you are next.
Sure,
Yes.
I'll take it. Good,
Okay.
thank you. Thank you for being here today. So you were in the room when I asked the minister a question about stricter bail conditions and whether Bill C-48 and C-75 is the best that we can do, or could we write a stricter law that would pass constitutional scrutiny in court, perhaps using the Section 1 test under Oakes? Is that possible? Or is this the best that we can possibly do already?
I think Parliament, thank you for the question. I think Parliament always has scope to act in terms of that dialogue with the courts, informed by the Charter. The Supreme Court has said that the denial of bail is permitted where it is done so on the basis of just cause. You know what the Criminal Code articulates just cause. Mr. Brock spoke about those already, public safety concerns and public confidence in the administration of justice. Could another ground for just cause be developed? Yes, it could. And our role as departmental officials would be to support a government, if that was government legislation, and advising on the constitutional and broader policy implications associated with that.
Mm-hmm. In your opinion, sir, and thank you, Mr. Taylor, for that answer, but will the courts look at the current circumstances of society, for example? And I had raised an earlier question that only 50% of Canadians actually have confidence in our criminal justice system. Is that an issue, consideration that judges would look at when deciding whether or not a law, Parliament trying to be stricter on something passes constitutional scrutiny?
Indeed, the public confidence in the administration of justice is the tertiary ground for bail. It was one of the main policy drivers for C-48, so it is something that the courts would look at.
That's all.
Thank you so much. And I will now go for 2.5 minutes. Wasn't sure who was taking the 2.5 minutes, because I know we're a little bit out of the norm today. So please proceed. Mr. Maloney.
Sure. I'll pick up on something we spoke about earlier. So just to be clear, when it comes to bail hearings, bail applications, bail reviews in the courts in Ontario, those are handled completely by Crown attorneys who are hired by the provincial government. We established that earlier. So the federal government doesn't have the ability, it's not within their jurisdictional lane to go out and hire more Crown attorneys to create more capacity so that they have the ability to process more bail hearings. Just so we're clear. Is that an accurate statement?
Correct. The overwhelming majority of bail hearings would be conducted by provincial prosecutors. Federal prosecution, Public Prosecution Service of Canada would be responsible for federal prosecutions under the Immigration Act, for example, but generally correct.
Okay. And the same applies to then the physical facilities as well. I mean, the federal government just doesn't have the jurisdictional ability to go in and solve the capacity issue in the province, does it?
That's why we talk about a shared jurisdiction.
Okay. So all the federal government can do is make amendments to the criminal code, which is then applied to bail hearings, for example. I mean, what we saw in the media today was not only are the structural capacity deficiencies that you see in the province of Ontario causing a problem with respect to bail hearings, they're now resulting in diminished sentences. So people who have now been tried are going to have their sentence reduced because they were subject to these awful conditions in these provincial detention centers. So the only way to address that issue is to address the capacity issue with the Crown attorneys and the provincial detention centers.
Correct. I mean, that's a critical piece in terms of the administration of justice and improving efficiencies.
Thank you. I'll stop there.
Thank you for that. Monsieur Fortin?
Merci, Madame la Présidente.
Thank you, Madam Chair. Quickly, I understand, and my respected colleague, Mr. Maloney, has explained what falls to provincial jurisdiction rather than federal jurisdiction, because often there is bickering on a daily basis on this question of who has jurisdiction for what. Now, in your departmental plan 2024 to 25, you indicate that only half of Canadians believe that we have a fair justice system for everyone, and the target for the minister was 70%, unless I'm mistaken. So if we're not able to manage the administration of justice in the courts that fall under provincial jurisdiction, we can appoint judges at a federal level, and there are delays. What else can we do? How are you going to increase the confidence of Canadians in the justice system to get it above 50%, which is a little bit pathetic, if you don't mind me saying so?
Oui. Merci de la question.
Yes, thank you for that question. I'd just like to underline what we've already mentioned, namely, it's at the FPT meetings that ministers actually discuss these issues together, because we are talking about shared competences. So is it just with these meetings that we can do this? Well, that's where we develop solutions. They might be legislative or pragmatic solutions, but we have to do this together, because sometimes adopting federal laws is one thing, but provinces don't always have the resources to actually put these into effect. And so what about the departmental plan, and what can it do about this? Well, partially, briefly, please. There's the investments, as has been said, in terms of legal aid. And investments in the criminal legal aid will help a little bit to overcome these difficulties with the system as a whole.
Monsieur McGregor?
Thank you now, Mr. McGregor.
Thank you, Madam Chair. I would like to ask the officials about the supplementary estimates that are being earmarked for the Law Commission of Canada. So you have proposed authorities to date of around $4.6 million, and these supplementary estimates are going to provide an additional $735,000. Now, I know the Law Commission provides very important research that can help guide public policy, but I was very interested in the research project that they're doing on prison law, because the other committee I sit on is the Standing Committee on Public Safety and National Security. And of course, we're very familiar with the Correctional Service of Canada and also the Office of the Correctional Investigator. So, I mean, I guess that what I would like to know in practical terms, how does the Department of Justice think that this research is going to be used? Like, what are your hoped for outcomes? And are you working hand in glove with the Department of Public Safety on this as well, like the research that you will receive from the Law Commission of Canada? I'm just curious because I wear both hats at two different committees.
Go ahead. You want me to? I mean, I would just say from a policy perspective, we work obviously very closely with public safety. We have good relationships with the Law Commission. I think the specific issue that you've identified will be of more interest to our public safety colleagues, but certainly something that we would be following closely as part of the kind of the policy development process that we do. Mr. Kroll, did you want to supplement?
No, I was just simply going to say that we are not in a position to speak to the supplementary estimates for the Law Commission. That's a separate department. You would be best to ask them about the funding they're seeking.
Thank you. Thank you to the witnesses and thank you to colleagues. I have a number of questions and votes to go over, and I'm simply going to read what I have in front of me. Shall vote 1B under Administrative Tribunals, Support Service of Canada carry?
On division.
Thank you. Shall vote 1B under Canadian Human Rights Commission carry?
On division.
Thank you. Shall vote 1B under Courts Administration Service carry?
On division.
Thank you. Shall vote 1B under Department of Justice carry?
On division.
Thank you. Shall vote 5B under Department of Justice carry?
On division.
Thank you. Shall vote 1B under Law Commission of Canada carry?
On division.
Thank you. Shall I report supplementary estimates B 2024-2025 to the House?
On division.
I'll be on division. Okay, thank you. Well, we've come to the end of the session. Well, thank you very much. We're actually a few minutes early. That was very nicely done by members, and thank you very much, everybody, for your efforts in getting through the supplements. Have a wonderful afternoon, and we'll see everybody next time. Thank you.